Morning.
Morning.
Okay, we were talking about yesterday. Oh, there we are. We were talking about yesterday about the idea of a person wanting to claim, I signed a contract giving you permission to expand your merpeset, but I wasn't aware what I was signing. So he's quoted a number of poskim that are in accord with the way Marv described secular law, that it's very hard to make such a claim that I didn't know what I was signing on. And he says, "V'chein kosav hakneses hagdola keshehu atzmo chotei mechayvin oto." That the Knesset Hagdola writes the same thing, that when you sign yourself on the dotted line, you are obligated shechazakohu delo chasam adiyadia my deichtiv, because we assume that you would not have signed unless you knew what you were signing to. Or we say that even if you didn't know, the fact that you signed means you placed your trust in whoever was putting the paper in front of you to abide by whatever terms they would do for you, which is another argument, by the way. Like when you upgrade your the operating system on your iPhone, you have to click and say I accept all the terms, right? I don't think too many people read them.
Anyway, it's like 400 pages. Scrolling, just keep going down.
Yeah. So you're basically saying, I have confidence that Apple will not succeed as a company if they try to pull any fast tricks on their customers. So therefore, I agree, right? So yes, it's true. We assume that most people have not read that, but we also assume that you're committing yourself to those terms because you trust the company or the person that's putting that in front of you. Lefiza nira de'in lekabel et eduto shel hashachein afilu im haya eid kasher. And therefore, in conclusion, because part of this shaila was, not only am I claiming I didn't understand, but my neighbor is testifying in Beis Din, or he wants to testify in Beis Din that he saw that I didn't understand what was going on. He says that is not admissible testimony, even if he's a kosher witness and is not nogeya badavar, even if he has no personal interest. De'ein be'iduso klum l'shanot et psaka shulchan aruch, because his testimony will not change the psak of the Shulchan Aruch. Now, the Afal Pishi Yesh Edim Shuhu Lo Yadav Lo Haven. The Ramban writes that even if a person can verify with witnesses that he didn't understand what he was doing, he's nonetheless obligated to honor and uphold his signature. We're going to have another tshuva later on that's going to address this issue.
Because otherwise the whole system would fall apart. I mean, if you couldn't put your terms down and get the person to agree, then you can't have a contract.
But, to that issue, Marv, is it possible that, like, if you have, let's say, a 25-page contract in small print, and you as a lawyer know very well that you can always expand the size of a contract with wherefores and therefores and whereases, and just to pad it, right? And in the middle of like the 23rd page, you put in some vital clauses and information trying to hide it. Can that be argued in a court of law?
There's a famous case called the Tilden rent-a-car case. Somebody rents a car and, signs it or whatever, and buried in there was a waiver of liability clause. The guy gets in an accident and he said, what the heck? You're not covered. The court basically said, for serious clauses that have consequences that are not brought to your attention, but ought to. They should have been bolded or whatever it is, buried within, 10 pages of text, saying that's not a valid contract on that clause. That clause does not have effect unless it's brought to your attention. So that is the law.
And sometimes in some contracts,
specifically brought to your attention.
Yeah, like in real estate, they actually make you initial certain things.
Yeah, that too. Yeah. And some of the plot, like I was saying, when we went to Harrisburg for the kids' plaything, whatever, buried in there also is, not buried, but at the end, in bold, is I agree that I've had 20 minutes to read the pit or whatever it is, sufficient time to read the contract. And I've been afforded the opportunity to get legal advice. They make that bold.
That's for the waiver,
Right,
right?
that's part of the waiver, part of your contract too, saying I've been afforded the opportunity to get legal advice and I've declined it, whatever. That's the reason they do that. Yeah. So, yeah.
That's why you signed it, Mark.
What's that?
That's why you signed it.
Well, you have to do that as a precondition of getting.
I know, I know.
The kids never talk to you again.
Yeah, yeah, I mean, like, well, it's so dangerous anyway. Whatever.
Social pressure.
Yeah. Yeah, but all these things have been thought about and now are in these contracts because of these kinds of cases. So, yeah.
Rent a cars on 40s.
Yeah.
or Stuff like that.
Yeah, so now the laws, they have to bring sort of weird stuff to your attention.
Shipping documents, whenever you ship those also you want insurance, you have to some, yes, no.
Okay, ready for the next tshuva? Okay. Tainus paraiti keneged ktav yado shehu chayav. A person, the claim of I paid you back when it's against a promissory note that shows that you owe money. Okay, so Reuven hotzi al Shimon shtar sheshimon kasav b'ksav yado shehu chayav l'Reuven sikum kesef gadol. Reuven produces an IOU that was written in Shimon's handwriting. And Shimon wrote, I owe you a significant, let's say $10,000. Okay, ve'ein al ashtar chatimot shaledim. The piece of paper does not have witness's signature, it just has his own signature. Aval hushtar rishmi shal hamedina shememalaim et pratei halva'a bichtav yad. But legally, from the state's point of view, it's still a legal instrument because it was written in the handwriting of the debtor. V'yesh l'shtar kazeh tokef al pi hachok, and therefore the government says that this is a legally binding promissory note. Okay? Shimon toin l'Reuven shekvar paralo mizman. Shimon claims, I paid this back over a year ago. Ve'he'emin lo shelo yotzi alav et hashtar od hapam. And I trusted you as a friend that you're not going to try to play any shenanigans and claim that I still owed you the money. Aval Reuven toin sheshimon me'olam lo shilem lo. But Reuven claims, you never paid me. Hadin im mi. Who is going to prevail in this case? All right, Mr. Huberman. Bum. Okay, go ahead.
Creditor, I think we did this already.
We did. We early on in Baruch Omer, because I just wrote it up for this week's bulletin in the Choshen Mishpat corner. Just a simple IOU is legally binding. Even halachically, I think that's what we said. But when the debt is paid, no rational debtor, no rational borrower is going to pay back the loan without getting the promissory note back and tearing it up. So there's a claim against him.
But I
If-
know you get the receipt too.
Yeah, if you already paid, why didn't you get some receipt or at least get the original IOU back and tear it up? So let's see what he says. Isa b'Mishnah, hotzi alav ksav yado gova min achasim b'nei chorim.
We had this stuff, you know.
Yeah, for sure. Yeah, well, that's where do you think we got it from? Okay. All right. The Mishnah in Bava Basra, so right, it was in Bava Basra. So that if a person brings a note that says that he owes money and it's in his own handwriting, but there's no witnesses on it, he can collect on that note, even though he can't collect on encumbered property, right? He can collect on unencumbered property. Do you understand when we talk about encumbered property, what does that mean? There's no lien on the property from before, right? In other words, so if let's say someone else has let's say a claim on my real estate, or that real estate has already been paid off from a more recent debt, the person with this promissory note that predates it cannot collect from that property that has already been committed and given to somebody else. Okay, because of hatur, im toen halova parati, neman v'nishba hestes v'nifter. However, the Torah writes that if the borrower says, I paid this back already, he's believed and he can take a shvua to make himself putter. Ve'ein hamal v'yachol omar shtarcha b'yadi my boy. And here the lender cannot say, well, why then is the promissory note still in my possession? She'eino choshesh lahanicho b'yado kevin she'eino shtar gomer. And the argument of the Torah is that the debtor has a good argument. His argument is, well, it's not really a totally valid promissory note, and so therefore I never borrowed to take it back from you. I figured it's just a scribble of my handwriting that I owe you $10,000. Who's going to uphold that in court? Because it's not you can't collect encumbered property with that. Because of Balamor, Bezelushona. Kosav harif bahalachos de itoin loiva al ksav yodo v'amar paraiti neman b'pnei shedino kemil v'alpeh. And actually, the Rif is quoted as saying the same thing, that if the debtor says, I paid back already, he's believed because he can claim it's like I paid back on a loan that was done just without paper at all. Velonit bar li zehadavar, and the Baal Hamor says, I'm not so clear on that. Ki nirali de laolam yachol amemer leheich shtarcha biyadi my boy. The Baal Hamor says, I don't agree with that. I think that if a creditor has paper, he can always say to the debtor, how can you claim that I paid you back? Why then am I still holding on to this note? Uda Amar Rav Papa, Haiman demapik shtara achavre v'amar leidach periyahu lav kol kamine. As Rav Papa says that when a person produces a note, then the debtor is never believed to say that he paid back. Nirali ki klalhu ben b'shtarchov ben b'ktav yado. He says it shouldn't make a difference whether it's a full-blown promissory note with witnesses or whether it's just an IOU in his handwriting. V'chein nira milashon mishnasenu sheshaninu stam goyvim menachasim b'nei chorin. Ve'ilu haya kedivrei harav haya l'tana demasnisin l'farish v'lomar imtan v'omer paraiti neman ad kan loshana. And the Balamor completely disagrees with the Torah, and he basically says the language of the Gemara says that with an IOU note that doesn't have witnesses but has his handwriting, the guy cannot say I paid back, and that's indicated by the Gemara because the Gemara itself just basically says you can collect from unencumbered property without any qualification, without saying unless the guy says I paid back. Aval kosav haramban b'milchama sham v'zelushano v'harei kreisa bein shineha sheshaninu al yedei edim goyvim minachasim b'nei chorin. So the Ramban disagrees with the Baal Hamor, and he says this is a phrase in the Gemara. A woman can never say if there's prima facie evidence against her having not being a virgin, she cannot say I'm a virgin. Let's say her placenta is in between her teeth. In other words, it's a phrase basically saying, obviously, you're not a virgin if you've been pregnant before, right? So, like, there's such prima facie evidence against you.
Immaculate conception.
Sheshaninu al yedei edim govim menachasim b'nei chorin. That it says in that same Mishnah or same Gemara that it says you can collect using witnesses on that note. The kaimalan einot sarach lefaro be'edim, and we have a principle that a debtor does not have to pay back with witnesses. V'lo pirei shatana imtan v'amar paraiti neman, and it doesn't. The Tana just simply didn't specify whether or not the case of when the debtor says I paid back. And the Ramban is pretty sharp in his language. He says, if anything, the indication is the opposite, that it seems like you have to have Adim that witness the loan for a guy to be able to collect using this note. And the reason why the Rif didn't specify that if the Lova says I paid back, he's believed, is because it was implicit and obvious. And he says, and even though the Baal Hamor says he's not clear on this. Other great rabbis are clear on it. And all of the earlier rabbis and the later rabbis have agreed by consensus. And the reason is because debtors in general will look at such an IOU note as not being a serious legal instrument, and therefore they'll let the creditor hold on to it even after they pay. And the reason why they will never say I paid back when there are witnesses who sign on that paper is because such a shtar has a legal weight to it. It has what's called a kol, which means people will hear about it. And that's the reason, because it can collect even from encumbered property. And that's the reason why we don't believe someone when he says, I paid it back. Then why didn't you get the note back? But in all other notes that are more featherweight, more lightweight, we believe a lova when he says, I paid back. Now he says, V'harav hamagid hisber atam dekeven shenagova mimishabdi lo chashash lahanicho biyado dahayibo yohivu mazmin lekulu nichsi velo tarif midi. He says, and the Magid Mishnah says the same thing. He says, if a person wishes to absolve himself from paying back a debt that's only on unencumbered property, he always has a solution. He could always sell all of his property and divest himself of any cash by giving it, let's say, to his family. And that way he can squeeze himself out of not having to pay his debts by claiming to be penniless. You can only do that if the debt is an unencumbered debt, debt on unencumbered property. So that's the reason why a debtor will not take it seriously. I mean, that's the argument, right? You hear that argument, is that you can always squeeze out of a debt that's only on unencumbered property. Even though the Bach says the same thing. Same argument as the Magid Mishnah. Okay, now, this is all bringing us case history, where an IOU that is simply signed by the debtor is not strong enough, because it doesn't have witnesses on it, to collect from encumbered property. And so based on that, there are a number of Rishonim who say that because it's a weak document, it's a weak instrument, the lova, the debtor, would be believed if he says, well, I paid you already. And don't claim, well, then why is it still in your hands? Because it's a lightweight thing. I didn't bother with it. That's the argument from a number of Rishonim. Now, here comes along Rav Shraga, and he says, "Umei odi lo zachiti lahavin chiluk zeh." That for many years, he says, I really never understood this claim. De'ein lecha adam she'ein lo dira shetzarach lagur ba u'metaltalim u'shar chafatzim shetzarach lehishtamesh b'hem. Show me a person who is completely penniless, who doesn't have a place to live and doesn't have furniture and clothing and household items that he needs to live with every single day of his life. V'im kain yecholim legabos me'osim dvarim. So what kind of argument is it that the reason why the lova didn't take it seriously is because he could always divest himself of all possessions? Who's going to do that? How can a person divest himself of every single possession that he owns? And so, like, why would a person have that kind of psychology? Ubizman hazeh yesh lo bituach leumi uchidome v'hamal v'yachol la'akel lo otam. And especially nowadays, when people have bituach leumi, which is a certain guaranteed minimum, wage? Is that what bituach leumi is? Is it? So I think it's Social Security, but that's only if you're a certain age, like a pension or something. And so the creditor could always garnish that. There's always something that you could take from a fellow Yid, no one is absolutely penniless. And so I never really was able to understand this argument that the Lova won't take it seriously because he could always completely divest himself and get out of paying the debt. Shuvra isi shekush yizu hiksha be'even ha'azel da'asu begavra artilai askinan below begadim below kelim below chafatzim ishiyim. His language is, what are we talking about? Naked people? He says, people have clothes, people have utensils, people have possessions. Everyone has possessions. Even the milva al peh goiva afilu miglima de al kaspe, because we know that oral loans that where paper has not been exchanged, the creditor can at least collect from all of your possessions, even from the shirt off your back. That's even written in the ksuva. You know, when a husband writes his wife a ksuva, he says, your 200 zuz that I'm committing to you is collectible afilu miglima of the al kaspoy, even from the shirt off my back. Like if you need to collect and all I have is the shirt on my back, I commit that to you as well.
You explain that to them when you're.
Sometimes I say I go to that extent, but I just basically say it's collectible from your entire estate, from all your possessions. And so why would a person let an IOU like that remain in the hands of a creditor? Dumya dishtar she'ein bo achrayus, afal gav de lo gavi memishabdi, matzal memishtar chabiyadi my boy, ve'enu neman lomar paraiti kinemuchach b'mitziyad kandevar. So the Eben Ha'azel is also puzzled by why you assess that a debtor is not going to care about letting the creditor hold on to an IOU like that. Amnam harash hevitam acher lazeh. However, now let's look at the Rush. The Rush gives a different reason for this argument. The betshuva hevi et shita tarif da hamotzi ksav yado al chavera matzil memer paraiti umishtabish v'os heses umiftar. That the Rush quotes the Rif, who had said, like from when the Baal Hamor quoted it also, that if you produce a promissory note with just the signature, not with witnesses, then the lova is believed to say, I paid it back. Vahatamhu de lo havi ela kamilva al peh. And the argument is that it's no better than an oral loan. My boy. So he says, why can't the Malva say, well, then why did you let me keep the note? The Rush's argument, and I think it's a valid, it's a very logical argument. He says, when I scribbled an IOU to you, I didn't remember to ask you for it back. He says, when we went to the bother of getting witnesses to sign on a legal document, on a promissory note, that's something that I would have remembered to ask you to take back. But on something like this, it didn't even occur to me to ask you for it back. This resonates with me because I lent someone $10,000 once and he paid me back and I forgot even to give him back the IOU. I had to tear it up later when I realized, hey, I better not hold on to this. Like if something were to happen to me and my kids found this, that would create big problems for the guy. And my kids would illicitly try to extract the same debt from this person all over again. And the reason is because a promissory note that's signed by witnesses is something that has weight to it, and everyone's going to remember it. The people may not even remember that they wrote an IOU. The adif eid echad bishtar mishnei eidim bal peh mishum the eid echad bishtar matzi amar leishtarcha biyadi my boy. The Beis Yosef now addresses, what if the shtar is signed by one witness and not two witnesses? Well, he says that has more weight than an oral loan that's done even in the presence of two witnesses, because anytime you get someone to sign on a piece of paper that's not a party of interest, then that really is something that the creditor can say, well, why did you let me keep the note? Below dami lahotzi alav ksav yado de ksav yado kevin she'ein Sham eid chatum bo lo mashma le'inshi dili havi shtar litchayev bo. That the Beis Yosef gives the same argument. He says, when you just write an IOU with your signature, people don't pay attention to that. They don't take it seriously. He says the same argument. He says when a person writes an IOU, people think that it's just to remind us how much money was lent, and therefore people don't take it as seriously. V'chein kasav harambam v'zelo shono hotzi alav ksav yado shehu chayev lo ve'ein sham edim afal pi shehuchzak ksav yado beveistin hareze kemilva al pelech ol davar v'im toan shapora nishba hesis v'niftar ad kam l'shana. And the Rambam writes the same thing, that if a person produces a signed IOU that it doesn't have witnesses on it, even though even though the Beis Din recognizes that this is the debtor's handwriting, but it's still considered to be like an oral loan. And if the lova claims that he paid, he can wiggle his way out of it. Kasav Hanimuka Yosef. Let me just see how long this tshuva is going to go. Wow, this is okay. It doesn't go that much longer. Okay. Kasav Hanimuke Yosef, Kasav Shaharitva Beperk Shavuos Hadayonim, Shadas Hagonim V'Harambam de Mishtava Umifter, V'lo Matzi Amrlei Shtarcha V'Yadi My Boy, Ela Bishtar Be'edim Shegova Menachasim Meshubadim, V'lo B'Chsav Yodo Shegova Mechorin. So he's really bringing back and forth a number of different opinions that go one way or another. Okay. Umaran b'Shulchan Aruch Pasak. So how does the Shulchan Aruch paskin? V'zel l'shana. Afilu im nitkayim beveis din shu ksav yado. Even if the Beis Din can verify that this is Shimon, the debtor's handwriting, ein lo ela din milva al pe be'edim ve'enogo v'lo min hayorshim v'lo min halakuchos ela mimenu im hoda shelo para. It doesn't have a valid status of a shtar that can extract from encumbered property. It can only be used to collect from the person himself. And if the person himself, the debtor, passes away, you cannot use this note to extract from the heirs. You can only accept from the debtor himself, provided that he doesn't claim that he already paid it. Aval im toin parati, neman v'nishba hesis v'niftar. If, however, he claims that he already paid it, as long as he's willing to take an oath and based into that fact, he can exempt himself. Ve'enu yochel lomer shtarcha b'yadi my boy, sheinu choshesh la'anicho b'yado kivin sheinu shtar gomer. And the creditor cannot claim, well, then why did you let me hold on to the note? Because it's not really a complete note. Ve'imodelo mixas nishba shvua deoraisa akan l'shano. And furthermore, if the debtor says, I paid back half of it already, and that's why I let you keep the IOU, so then he would have to take a shvua deoraisa, because he's called a moda b'miktsas, and you've learned that also in the Gemara. He's a partial admitter, and there we say that there's some suspicion. The Kosav Harama Bahagashon V'Zelashona. And the Rama writes, V'yesh omrim de'enu yachol omar parati al ksav yad akam l'shana. He throws a wrench in the whole thing. The Rama says, some say that you cannot make the claim of parati, I already paid it, when there's a promissory note that he signed. The Kosav Hasma, that what? V'chein pasak morenu. I'm not sure who that is. Aval Ashach Sham Pasak De'eker Kisvaris Maran Shisvaris Hagaonim V'Harif V'Harambam V'Harosh V'Ramban Aval Trumas V'Hator U'Maharam V'Rav Magid V'Rashbatz V'Sharposkim Rishonim V'Achronim V'Ayin Shamad Shekasov Lidchos Israyas Harashba Hanal. So okay, so basically the Shach says that even though the Ramah holds that you can't make a claim of parati that I paid back, but the vast majority of Rishonim are with the Beis Yosef, and therefore that's the accepted halacha that a person could claim parati. V'hine, b'nidon didan, in our case, milavad shadas haramahu de'enu yachol omer parati keneged ksav yado. Okay, so in addition to the fact that the Ramah paskins that you cannot claim parati, okay, I will have to hold it here. We're going to get to the that this is the final paragraph of the whole tshuva. We still don't know how to paskin. We know that there's a machlokes here. And generally speaking, when there's a machlokes, hamotzi mechaver olav haraya, then you're not going to be able to use this note to extract. But let's suspend judgment until we see Rav Shiraga's final psak. Okay?
But this is all, obviously, this is all talking about the zoning.